Hello class, and welcome back to POLI 101, the Government of Canada. Today will be the last lecture before the midterm exam. So in the interest of getting right to business, let's get started. Today's topic is the Charter of Rights and Freedoms. Last week, we began our exploration of the Canadian Constitution, focusing on the pre-charter era of 1867 to 1982. Today, we're going to examine how the Charter of Rights and Freedoms has entrenched individual and group rights within the Canadian Constitution and empowered the courts to act in ways that they previously had not. This is an important way for us to close the first half of our semester studying the government and politics of Canada, because so far we've focused on the people of Canada, the demography of Canada, and the transformation of the Canadian state from the earliest days before Confederation during the colonial period, through the development of Confederation into the Canadian state that we see today. How does the Charter of Rights and Freedoms wrap up some of the issues that we've been discussing, such as Indigenous rights, linguistic rights, and the rights of all Canadians within a parliamentary democracy? We're going to explore these issues today as we discuss the Charter of Rights and Freedoms in our continuing exploration of the structure of Canadian government. We have 3 learning objectives for today's lecture. The first is to introduce some basic issues surrounding rights and freedoms by examining the United Nations Declaration of Human Rights, as well as the status of rights and their protection during the pre-charter era in Canada. We'll then move on to look at how rights have been protected since the Charter of Rights and Freedoms was introduced in 1982. We're going to review the 7 categories of rights protected by the Charter. We'll also look at how Canada performs on rights protection in global perspective. We'll look at the supposed Americanization of Canadian politics that has taken place since the introduction of the Charter. And we'll also look at what limits can be placed on the rights found within the Charter. Finally, we'll take a more detailed look at court cases that have applied the Charter to various issues in Canadian political life and which have clarified the scope and authority of the Charter, as well as the relationship that exists between individuals and their rights and the power of the state and of legislatures. Finally, we'll conclude with a look at a contentious issue and the politics surrounding Quebec's Bill 21, which someday might end up in front of the Supreme Court. How might the court rule on this issue related to religious symbols in public life in Quebec? Perhaps the accomplishment of today's learning objectives will give us a good idea of where this issue will go in the future. Let's get started. Let's start with a general understanding of rights and freedoms. Rights are individual or group entitlements that are considered so fundamental to human dignity that they must receive legal protection. The defense of these rights is often going to require government action. Otherwise, these rights might be violated by other private citizens or perhaps by the government itself. And so freedoms involve an individual's liberty to do or believe something without any government restraint against doing or believing that thing. And so what civil rights are the protection of these freedoms that are basic to human dignity and basic to a participatory democracy. And so civil rights is the protection of these liberties through legal protections and strong courts, and as we'll see, entrenched rights within a constitution. This is the best way to guard against government interference in individual and group rights. To better understand the topic of rights and the sorts of rights that we see in constitutions around the world, including within the Canadian Charter, is to look at the United Nations Universal Declaration of Human Rights from 1948. This was very early in the United Nations history, just a few years following the end of World War II. And the United Nations Universal Declaration ended up setting a standard code for the types of rights that we would see in constitutions that would be written in the post-war period. And the first type of rights that we see in the Universal Declaration are political rights and fundamental freedoms. These include the freedom of association, the freedom of assembly in public, the freedom of expression, the freedom of a media and a free press, and the freedom of religious worship. Governments are not supposed to limit or abridge the exercise of any of these freedoms. Second, democratic rights are the right to vote and run for office in free, fair, and frequent elections. And this is the second type of rights that we see in the UN Universal Declaration. Third, we have legal rights, and these are mostly procedural rights related to the due process of law and the rights of those accused of crimes. For instance, the prohibition of cruel and unusual punishment and the access to legal counsel. The fourth category in the Universal Declaration are economic rights, specifically the right to own property and to not be denied the right to own property or to have that property taken away without due compensation from the government. Fifth are equality rights. And equality rights are those regarding access to rights regardless of race, color, sex, language, religion, political opinion, or national origin. And so these 5 categories of rights are found in the United Nations Universal Declaration of Human Rights. But what exactly is the Universal Declaration? It was a resolution passed by the United Nations General Assembly. General Assembly resolutions do not have the force of binding international law like their counterparts from the Security Council do. However, General Assembly resolutions do carry normative weight, and they do have influence on the development of norms and the development of constitutions, in this case, in countries around the world. And so, while countries are not bound to implement any of these 5 categories of rights within their territories, we have seen many countries adopt them nonetheless. We'll get to the issue of whether rights are absolutes or can ever be moral absolutes in a few slides from now. But it's worth remembering that no country is obligated to adopt these rights into its constitution, but many countries like Canada have done exactly that since the end of World War II and the introduction of the Universal Declaration of Human Rights. Let's say a few more words about the types of rights that we find in constitutions around the world. We're going to divide these rights into 2 different categories: negative liberties and positive liberties. Negative liberties are restrictions on state power, restrictions on the state's ability to intervene in social and political and indeed in economic life. And so an example of this would be that government shall not establish an official religion. This is just one of many prohibitions on state power that we find in the United States Bill of Rights, the first 10 amendments to the US Constitution, which are just a series of negative liberties outlining what the government must not do and cannot do in terms of intervening and infringing on individual liberty. And so negative liberties are usually found in constitutions that were closely modeled after the United States Constitution of 1789. For instance, in the presidential constitutions of Latin America that closely resemble the United States Constitution. On the other hand, positive liberties are those that are enabling conditions that the state must provide to make sure that everyone has the full potential for their self-realization and for their human development. This means that not everybody has an equal starting place in life, and sometimes the government has to take positive action to try to help everyone accomplish their full realization of their skill set and the full development of their self. And so, to take an example, the South African Constitution, after apartheid, the South African Constitution that established a democracy in that country, has a right that says that the government shall use all available resources within reasonable effort to promote universal housing. And so access to housing is a right that is protected under the South African Constitution. But this is a right that, if it's going to be accomplished, is going to take a lot of government action and a lot of public policy related to housing and urban development. And so universal housing won't just be created by writing down a right on a piece of paper and even by entrenching that right. Positive liberty suggests that states and governments must take action to help individuals achieve their rights and to fulfill total human development for the country. And so we tend to find positive liberties more often in post-World War II constitutions, because these positive liberties in some way are modeled after part of the UN Human Declaration, which does refer to the power of national governments to ensure these rights and liberties are achieved. Whereas negative liberties are found in older constitutions, it's the post-war constitutions that tend to include more positive liberty. In addition to the 5 categories of rights in the United Nations Universal Declaration, some countries choose to protect additional categories of rights. For instance, as we'll see in Canada, Indigenous rights and language rights are also protected categories under the Charter. The framing of issues as rights issues can be a controversial one. And this is because when we invoke an issue as being a rights issue, it can tend to frame it as an issue of moral absolutes. And so the revoking of an issue or the changing of an issue can become much more difficult if it regards something that is entrenched as a constitutionally protected right. Let's take the example of immigration. Immigration can be framed in a couple of different ways. We can choose to look at the issue of immigration through the lens of economics and the benefits of immigration on a country's economy, as well as on national security and the impacts of immigration policy on national security. However, we could also look at immigration as a human rights issue related to mobility, refugee status, and asylum seeking. And so how we choose to frame the issue of immigration can perhaps make the courts or public opinion react differently to the right direction that public policy should take to regulate that issue. But we have to keep in mind that framing issues in the language of rights can make it difficult to oppose anything about these issues because it invokes moral absolutes. And so ideas of justice and what constitutes a good life will, of course, vary between cultures. There is not a universal doctrine of human rights accepted around the world. Yet, what is important to know is that in a multicultural democracy like Canada, there are going to be conflicts between the openness of a democratic society and the protection of group rights that is required under the Constitution, but also the conflicting visions that people have within Canada about what is right, what is just, and what constitutes a good life. And these are issues that rights and freedoms and the Canadian Constitution touch on directly, and we're going to explore them in depth today. Let's touch briefly on the protection of rights in the pre-charter era. From 1867 to 1981, rights had just a marginal or a bit of an ancillary place in Canadian politics. Why is this? Why is it that the issues of rights and discussions of rights are missing from some of the earliest textbooks on Canadian government and Canadian law? One of the major issues is federalism. As we discussed last week, federalism is one of the 4 basic principles of the Canadian Constitution. And in the Constitution Act of 1867, there are very few references to the rights and freedoms of Canadians, of individuals. However, the Constitution Act of 1867 does have very detailed information about the rights and the processes of federal and provincial governments. And so this divide between federal and provincial jurisdiction was the important one to justices. the courts were unwilling to overrule the authority of elected legislatures as long as the legislatures were operating within their jurisdiction. That is to say, as long as Ottawa was only making laws for the federal government, and as long as the provincial government was only making laws in areas that are outlined as being for provincial authority. It doesn't matter if the laws being made infringe on the civil liberties and the individual freedoms and rights of Canadians, as long as the jurisdiction is correct. And so we'll see that this is a very far cry from what we see today, where the Constitution has supremacy. During this era, there was parliamentary supremacy. At the same time, public opinion tended to believe during this period that individuals' rights were being protected, or at least protected well enough. And so the majority opinion in this case was that Canadians and their rights were being protected how they had always been protected, through legislatures that were prudent and responsive, by common law institutions, and by a vigilant public, which was the same exact system that Canada had inherited from the British. And of course, to this day, the British still have an unwritten constitution and this sort of method of protecting civil liberties and rights. So the system can work. But as we'll see, Canada made a change in 1982 from parliamentary supremacy to constitutional supremacy. Before the shift to constitutional supremacy was made final, there were some early efforts that were unsuccessful to try to move in that direction. Most notable among these is the 1960 Canadian Bill of Rights. This was the idea of Prime Minister John Diefenbaker, whose conservative government had won the election in 1957. And at that time, as discussed, public opinion, as it had always said, was that Canadian rights were pretty well protected, and protected well enough. But civil libertarians, that is to say defenders of civil liberties in Canada, such as the Canadian Bar Association, an association of lawyers, that is, they argued that civil liberties would be much better off if they had the protection of a Bill of Rights entrenched in the Constitution, that is to say, a document like what would become the Charter of Rights and Freedoms. The Diefenbaker government attempted to do this just through regular legal statute, that is to say, just by passing a bill in the House of Commons known as the Canadian Bill of Rights. And while the bill passed successfully, it did not have the same impact that the Charter would have 20 years later. Because, as we'll see, when the courts had the opportunity to use the Canadian Bill of Rights to strike down laws that were infringing on individual rights and freedoms, the courts repeatedly turned down this opportunity, except for one notable case known as the Queen versus Drybones in 1970, where the Supreme Court struck down a provision of the Indian Act that made it illegal for a status Indian to be intoxicated off of reserve land. This law clearly violated the equality provisions in the 1960 Canadian Bill of Rights, and the court struck down that provision on that basis. This sort of action, the judicial review of a law passed by a legislature and the striking down of provisions that violate the Constitution, is a regular practice now of judicial review in Canada. But this was exceedingly rare before the Charter, and only once did a notable case happen, and this was the Drybones case, where the Canadian Bill of Rights actually led to that result. Otherwise, the Bill of Rights did not succeed in entrenching these rights and freedoms in the Canadian Constitution. That would have to wait for the Charter in 1982. During the pre-Charter era, to be taken seriously, a rights claim had to be repackaged as a federalism issue, and the decisions being passed down by the courts rarely referred in an explicit way to the protection of individual rights, and rather focused on whether governments were in their proper jurisdictions. In Saumer versus City of Quebec, a 1953 case about a law that prohibited the distribution of literature in public without the permission of the chief of police, we saw that the court didn't really look at the issue that this was a free religious expression topic because Jehovah's Witnesses were being targeted by this law because they could not pass out their religious pamphlets in public anymore. And so this issue that is clearly about the free expression of religious belief and ideas was not something that the court really entertained in those terms. Instead, it just said that this is all about the jurisdiction of governments and that this issue is not necessarily beyond the scope of legislatures. As long as the legislatures are staying in their respective lanes, then this is an issue that they can make laws about. Similarly, in Attorney General of Canada and Dupont versus Montreal, a 1978 case, we saw that there was a restriction in Montreal on free assembly, and this was in order to try to prevent public demonstrations and civil unrest. And again, this was an issue that was considered purely on jurisdictional lines. The difference here is that this was 18 years after the Canadian Bill of Rights had been passed by the Diefenbaker government, whereas the Salmer versus City of Quebec case did not have a Canadian Bill of Rights to look at that had tried to entrench religious freedom in the Canadian Constitution. This Attorney General of Canada and Dupont case v. Montreal, they did have a charter, well, not a charter, right? This was before the charter, but they did have a Canadian Bill of Rights document that protected the freedom of assembly in public. And yet, the fact that the court was unwilling to use the Canadian Bill of Rights like it had done in the Drybones case showed, as Justice Beets wrote in that case, none of the freedoms referred to in the 1960 Bill of Rights is so enshrined in the Constitution as to be above the reach of competent legislation. And so this showed that the Canadian Bill of Rights was not going to be sufficient to entrench rights in the Constitution, and what would be needed was a new Constitution Act. And that's what the Charter of Rights and Freedoms would produce in 1982. Let's move to our second learning objective for today's lecture, which is the protection of rights under the Charter. We'll begin to look at this by looking at how the court's role has changed in Canadian politics. Thanks to the Charter, judges no longer hesitate to question the substance of laws passed by Parliament and passed by the provincial legislatures. The judiciary, meaning the courts, now play a much more important role in Canadian government. There has been a large increase in the number of rights cases brought before the courts. And in the first 10 years after the Constitution Act of 1982, the courts decided about 1,000 charter cases annually, with the Supreme Court, the highest court in Canada, making about 20 to 30 charter decisions a year. This pace has slowed slightly, and between 2012 and 2017, we see that the Supreme Court decided between 12 and 20 cases per year that dealt with charter rights issues. But it remains the fact that Canada has one of the 4 most activist judiciaries in the entire world in terms of its ability to hear cases related to fundamental rights and freedoms, and its willingness to overturn or strike down provisions of laws that infringe or interfere with those freedoms and rights. The United States, Argentina, India, and Canada are the 4 countries with the most activist judiciaries in this regard. And this would not have been true if not for the Charter of Rights and Freedoms of 1982. Let's review the 7 categories of rights that are protected under the Charter. We discussed this a bit last week when we looked at how these categories were, or in many cases, were not protected in the pre-Charter era. Let's see where these rights are entrenched in the Charter by looking at the specific sections. Also, we'll see that the first 5 of these 7 categories are the same categories that we see in the United Nations Universal Declaration. This is not a coincidence. We also see that Canada's distinct political culture is represented by numbers 6 and 7, language rights and Indigenous rights, which are clearly values that are important in Canadian political culture, important enough to be entrenched within the Constitution. Starting at the top with the political rights and the fundamental freedoms, Section 2 guarantees the freedom of religion, the freedom of expression, the freedom of media, the freedom of assembly. These are important fundamental freedoms that we see protected in all liberal democracies. The democratic rights are protected in sections 3 through 5, which secure the right to vote for every Canadian, as well as the fact that a government cannot endure for longer than 5 years. Legal rights, such as due process rights related to the life, liberty, and security of all Canadians, so that they are not made to suffer cruel or unusual punishments, so that they have the rights of the accused, like the right to legal counsel and a speedy trial. These are protected in sections 7 through 14 of the Charter. Economic rights related to mobility are in section 6 of the Charter, as well as implied elsewhere. The courts have said it's implied elsewhere. We also have equality rights in sections 15 and 28, establishing that people cannot be discriminated against on the basis of race, sex, religion, color, gender. Then we also see, as I mentioned, language rights in sections 16 through 23, and this is very important, as we know from our lecture in week 2 on French-English relations. And Indigenous rights in section 25, as we discussed in our week 3 lecture on Indigenous politics. These are the 7 categories of rights that had varying degrees of protection in the pre-charter era under the Constitution Act of 1867 and other various laws and legal decisions made over the decades and centuries. But they finally gained the power of entrenchment and the status of constitutional supremacy with the Constitution Act of 1982, that is, the Charter of Rights and Freedoms. To better understand the protection of rights in Canada under the Charter, it's helpful to look at Canada's position among all the countries of the world in terms of how it protects rights and liberties. Let's turn to Freedom House for some data. Freedom House is a non-governmental organization that measures and monitors the status of freedom in every country around the world. Freedom House gives a country a ranking as free, partly free, or not free on the basis of a 100-point score that it derives from a 25-question survey. These 25 questions on which countries can receive between a 1 and a 4, with 4 being most free and 1 being not free. They receive this score based on the quality of their protection of rights, protection of civil liberties, the freedom of their press, the ability of individuals to worship and speak freely, the ability to have strong rule of law and protection through courts and anti-corruption mechanisms. And all of these add up to a 25-question survey and a total possible score of 100. And we can see here the countries that do the best on the Freedom House survey. And they tend to be Western European liberal democracies, although we also see that Uruguay is represented here from Latin America with the same score as Canada, which is 98. This is a very impressive score and a top 10 performance in terms of the protection of rights if we use the Freedom House data. What we can also see perhaps in smaller print on the right-hand side of this slide is that last year in the 2019 report from Freedom House, Canada had a score of 99 out of 100. It decreased to 98 specifically because of the issue of Bill 21, which is a topic that we are going to cover at the end of today's lecture. Another way we can measure the protection of rights in Canada is by looking at the World Justice Project's Rule of Law Index. The Rule of Law Index looks at different factors of the rule of law, and fundamental rights is one of them. And we're going to look at the 8 different sub-factors that are specific types of fundamental rights protection and how Canada measures up against the rest of the world, against its region, and also against its income group. And what we're going to see is there are 2 areas where Canada is not doing as strongly as it does in other areas of rights protection. And the first one of these is 4.1, the equal treatment and absence of discrimination. We can go back to our lecture on Indigenous politics to see the issues that have pervaded Canadian politics and the discrimination of Indigenous peoples in the history of Canadian politics, and see that it's still an issue that deserves a lot of attention. And so on this topic, we have Canada with a rank of 29th out of the 128 countries assessed for this study. We can see on the other areas listed here, such as the right to life and security of the person, the due process of law and the rights of the accused, the freedom of opinion and expression of that opinion. These are all very strong areas for Canadian performance in terms of its global performance as well as its regional and income group performance. Similarly, we see that the freedom of belief in religion, the freedom from arbitrary interference with privacy, and the freedom of assembly and association are all very strong areas of protection for Canadian rights. But the issue of fundamental labor rights is another area where Canada doesn't perform as well, with a rank of 20th out of 128. The overall picture, though, if we take all 8 of these areas together, is that the protection of fundamental rights in Canada is very strong on a global from a global perspective. And the protection of these rights has been facilitated by the Charter of Rights and Freedoms. This transformation of the Canadian Constitution did not come without controversy. During the 1980 to 81 debate over the Charter, opponents of the Charter warned that it would Americanize Canadian politics. What does this mean? It means that appointed judges would play a more important policy role than they had previously, and that this increased power of judges who were appointed and not elected would come at the expense of elected politicians serving in the legislature. The issue of parliamentary supremacy and the supremacy of the legislature to act within its own domain, whether federal or provincial jurisdiction, that was going to be erased and replaced with constitutional supremacy and the interpretation of laws as being constitutional or not by appointed judges. And so supporters of the Charter actually saw this as a benefit, that judges would be the appropriate decision makers, because unlike elected officials, they would have a vested interest in the Constitution and not just a vested interest in pleasing voters to secure re-election to keep their job. Appointed justices couldn't be removed by an angry public, meaning they wouldn't try to cater to what could be changing or inconsistent public opinion, but rather staying true to the fundamental rights entrenched in the Constitution. Who is the appropriate decision maker in Canadian politics, and what is the relative balance of power, the appropriate balance of power between judiciary and legislature? This is a topic that was very important in the debates leading up to the adoption of the Charter, and it's going to be a topic we continue to explore after the midterm when we look at the issues of the legislature and executive powers in Canada. But the important thing to remember about this issue of Americanizing Canadian politics is that the difference between these two positions, that is to say constitutional supremacy, like the American-style Constitution, or parliamentary supremacy, like the British-style unwritten Constitution, is over how best to protect rights. And the American model says we need to entrench these rights in a single document called a Bill of Rights. And this is going to be a list of things that the government cannot do because they violate personal liberty. And so we need to put our faith in entrenched rights and our faith in the Constitution and the judges who interpret that Constitution and make sure that the laws are consistent with the Constitution. But those who prefer the British model of parliamentary supremacy, they're a little more doubtful about how judges might get a bit too activist and start legislating from the bench. Judge-made law is a fear that would cause legislatures to decline in importance. And so these opponents of the Charter and supporters of parliamentary supremacy are more inclined to trust in the prudence and wisdom and the democratic responsiveness of elected governments. That is to say that if the people want a law changed because it infringes on their rights, well then the government will listen to them and change the law. That's the legislative supremacy model. So, can we answer the question, has the Charter Americanized Canadian politics? What we'll see is that Canadian judges have interpreted the Charter in distinctively Canadian ways, which reflects the unique political culture of Canada and Canada's unique jurisprudence. What this means is that just because Canadian judges now have the same powers under the Constitution to exercise judicial review and to interpret laws in light of entrenched rights within the Constitution, it doesn't mean that they're going to come to the same decisions on the important issues of the day as American justices do. And let's look at two prominent examples of where Canadian justices have made different decisions than their American counterparts. And these are the issues of hate speech regulation and campaign finance limitations. We begin with the topic of hate speech. And we see that here, the willingness of Canadian courts to restrict speech on the grounds that some ideas contribute nothing to democratic life because they are hate propaganda and spread by hate mongers. This is distinct from an American idea based on a First Amendment right of free expression, and that the ways that we challenge hateful ideas is with non-hateful ideas. They are going to be more successful in a marketplace of ideas. And so, whereas American justices are not as willing to limit free speech, usually only on the basis of if it presents a clear and present danger, Canadian judges, as we'll see from part of a decision in R v. Keegstra from 1990, it is through rejecting hate propaganda that the state can best encourage the protection of values central to freedom of expression, while simultaneously demonstrating dislike for the vision forwarded by hate mongers. And so we see here that Canadian courts are much more likely to limit free speech, at least in ways that limit hate speech, than our American courts. And so the power of judicial review did not produce the same outcome, but different interpretations of laws that limit free speech on the basis of spreading hate. The second issue is of campaign spending, that is to say, limitations on how much individuals and groups can donate to political campaigns during election season. And what we see is that in Canada, the case of Harper v. Canada of 2004, the Supreme Court upheld a federal law that was controlling how much interest groups could spend during election campaigns. And they made this decision based on the equality rights in the Charter. Restrictions were reasonable, argued the Supreme Court. Restrictions on campaign spending were reasonable to ensure a level playing field and to make sure that the wealthy would not exercise an undue or oversized influence on election outcomes. In this way, the court valued equality over the individual freedom of expression that is giving donations to political campaigns, which is a form of political expression, but one which the Canadian courts found does not outweigh a value of equality, especially when equality rights are entrenched in the Charter. In the United States, on the other hand, the infamous court case of Citizens United versus Federal Elections Commission from 2010 ruled that the First Amendment protected the freedom of speech, and the freedom of speech extended to giving money to political campaigns, and that this was a more important right than limiting the influence of the wealthy or limiting the amount that could be donated in an election. And so once again, we see that despite the supposed Americanization of Canadian politics by entrenching rights in a charter and empowering an activist judiciary with the power of interpreting laws in light of the Constitution, we're not necessarily having American results in policy outcomes and in judicial decisions. So far today, we've been discussing how the Charter protects rights by entrenching them within the Constitution. However, Section 1 of the Charter of Rights and Freedoms seems to place the potential for limits on these rights. Under Section 1, Charter rights are not guaranteed absolutely, but are guaranteed subject only to such reasonable limits prescribed by law as can be demonstrably justified. What are these reasonable limits that the government can demonstrate in order to encroach, that is to say, to limit one of the rights protected in the Charter? What exactly is the nature of these limits, and how often are these reasonable limits exercised? We'll investigate these issues now. The most helpful court case to define the scope and authority of reasonable limits that can be placed on charter rights is the Queen v. Oakes from 1986. And in this case, in the Oakes case, the Supreme Court set out a two-part test for deciding whether a limitation on a charter right was reasonable or not. The first part of the test is what we can refer to as a goals test. What is the point of the law? That is to say, is the government's objective in limiting a right of sufficient importance to warrant encroachment? Is the overall purpose worth limiting a right to achieve? That's the first part of the test. The second part of the test then is a means test. How does the law accomplish the goal set out in the first part of the test? Is the extent of the limitation proportionate to the government's objective? This idea of proportionality makes sure that the means used to accomplish the goal are consistent and proportionate with the overall objective. So, to illustrate the difference between these two, let's look at the law that was being questioned in Queen v. Oakes. The law here was a narcotics law, that if someone was convicted of possession of narcotics, they would automatically be convicted of trafficking or distributing narcotics unless they could prove themselves to be innocent of that additional charge. So the first part of asking whether this limitation can be placed on an individual's rights is the overall objective worthwhile? And so the court accepted the fact that the state has an objective in preventing the illicit distribution of drugs. The second part of the test, though, is where this law failed, because the burden of proof was being put on the individual to prove that they were innocent of some additional crime, whereas the burden of proof ought to be placed on the government. The government should have to prove this, not the person proving they are innocent. And so, for this reason, it did not pass the means test. The objective of the law was upheld, but the ways in which it was going to accomplish these goals were struck down. And so this is a way that the means and the goals tests can be used. And so what we also have seen is that the second part of this test from the Oakes decision is the one that is most commonly used. We rarely see the court object to the overall purpose, that is to say the goal of the legislation or the limitation, but rather the means by which the limitation is achieved is much more commonly going to be the reason that a law gets struck down or whether a reasonable limit is upheld. And so to say specifically more about the second part of the Oakes test, according to Oakes in the decision, for a limitation on a right to be accepted as proportionate, it has to meet three different conditions. First, the limitation must be rationally connected to the government's objective. Is the goal rationally connected to the means? Second, is the limitation going to impair the right in question as little as necessary to meet the government's objective? The goal here is to keep the limitation on the charter right as small as possible so that they achieve the objective and limit nothing in addition to what is absolutely necessary for achieving the objective. And then third, does the harm done to rights by the limitation, does it exceed the good that the limitation accomplishes? And so these three tests are used to decide that second part, that means test. These three conditions are used to determine whether a Section 1 reasonable limitation on any of the charter rights is going to be upheld as a reasonable limitation. We use the two-part test in Oakes to determine this. The first part of the test is not as often used, but the second part of the test, using these three conditions to determine whether the government's means to accomplish its objective are worth the limitation being placed on the right, That is the issue at stake, and it's the Oaks decision that helps illustrate how all future court decisions have handled these issues regarding reasonable limitations on rights entrenched in the Charter. To fully understand the reasonable limits that can be placed on charter rights, we need to look at Section 33, otherwise known as the Notwithstanding Clause. Section 33 allows Parliament or a provincial legislature, and indeed it was the provincial legislatures that pushed for the inclusion of Section 33 as part of their agreement to the Constitution Act of 1982. And so what this section does is allow either Parliament or a provincial legislature to pass laws that override Section 2 and Section 7 through 15 of the Charter. These include the fundamental rights and freedoms in Section 2, the legal protections in Section 7 through 14, and the equality protection in Section 15. The Notwithstanding Clause reads, Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature that the act or provision thereof shall operate notwithstanding a provision included in Section 2 or Section 7 to 15 of this Charter. What this means is that it seems like the provincial governments have a way to completely override any sort of meaningful protection in the Charter by passing laws that operate notwithstanding or regardless of the protections. And so civil libertarians and legal professionals were very critical of the Notwithstanding Clause when it was introduced. Because if the Constitution is the supreme law of the land, and we know that constitutional supremacy is supposed to be declared by Sections 32 and 52 Part 1 of the Charter, and so if constitutional supremacy is the new order of Canadian government, the new law of the land, then no part of the Charter should be placed beyond the power of judicial review. Why give provincial governments a backdoor option to getting around the legal protections that are supposed to now be enshrined through constitutional supremacy and a Bill of Rights embodied in the Charter? We'll see that this Notwithstanding Clause is controversial, but it hasn't been used that often in Canadian history. The Notwithstanding Clause has only been invoked a handful of times. Of course, this ignores the rampant use of the Notwithstanding Clause, at least in retrospect, that the Parti Québécois, the provincial party in Quebec, they retroactively applied the Notwithstanding Clause to all of their previous legislation and then would use it throughout the 1980s on all new legislation in order to show their symbolic disapproval of the Charter of Rights and Freedoms. Remember, Quebec is the only province that has not given formal legal approval to the Charter, but regardless of this withholding of approval, the Charter is still in operation. And so aside from this use, prominent use of the Notwithstanding Clause has not been that common, and usually it's only been used in situations where the public already approves of the limitation in question. Let's look at 3 examples. First, in Saskatchewan in 1986, there was a piece of back-to-work legislation, meaning ending the strike of public servants and forcing them back into their work in government. And back-to-work legislation to force government workers out of a strike and back into work is already pretty popular with the public. And indeed, this was not a controversial use of the Notwithstanding Clause, even though it appeared to violate the freedom of association that seems to allow a right to strike. We'll get back to this right to strike soon. Second, a very prominent use of the Notwithstanding Clause by Quebec, rather than its routine use of it, was in 1989 when it invoked the Notwithstanding Clause to repass its unilingual French policies. These were policies regarding French language education and French language and advertisement, as we discussed in our Week 2 lecture. Third, in Alberta in the year 2000, as a response to the growing acceptance, both in public opinion and also within the courts, of marriage equality, we saw Alberta attempt to reverse what was a growing trend of accepting marriage equality as unions not only between a man and a woman, but also between a man and a man, or a woman and a woman, or anybody of any gender. And so what we see is that this attempt to reassert a heteronormative definition of marriage was an attempt to use the notwithstanding clause, but eventually this redefinition of marriage, or this reassertion of the heteronormative definition of marriage as between a man and a woman, was eventually struck down by the Supreme Court. And so the use of the notwithstanding clause is not an automatic gateway to the limitation of rights. It's an opportunity for provinces through their provincial governments to try to put reasonable limitations on rights, but this is still subject to the approval and the interpretation of the Supreme Court. Let's move on to our final learning objective for today's lecture. Applying the Charter. What has been the general tendency in how the courts have interpreted the Charter? When the Charter first emerged in 1982, it was unclear how much it would really change judicial politics in Canada, and indeed the relationship between the different branches of government in Canadian politics. What we have seen is that the Charter has profoundly impacted judicial politics in Canada, and the courts have shown a willingness, as we'll look at in our first objective listed here. How have the courts interpreted the Charter's scope and authority? We'll see that the courts have interpreted the Charter as giving the courts the right of judicial activism, to not just have this power of judicial review in theory, but to use it forcefully. Second, what difference has the Charter had on the relationship between the state and individuals? Is the Charter and Charter cases, rights cases related to the Charter, are they advancing individual freedoms, or are they advancing societal protections? And what is the tension between these two issues? Then finally, we are going to close with an investigation of a recent issue in Canadian politics related to charter rights and related to multiculturalism and related to the differences between French and English Canada. And this is the issue of Quebec's Bill 21, which we will look at in the conclusion of today's lecture. Courts can either show restraint or activism. A restrained court chooses not to exercise its power of judicial review in proactive ways, whereas an activist court is much more likely to strike down provisions of laws or entire laws altogether if they violate or encroach on protected rights within the Constitution. The question of whether Canada's newly empowered courts would practice restraint or activism was answered rather quickly in a series of cases from 1985, as well as cases that would follow later in the decade. We're going to look at one specific case here on this slide, which is Singh versus Minister of Employment and Immigration. In this case, a portion of the Immigration Act was struck down, and it held that applicants for political refugee status did not get an automatic right to a hearing, but the court held that this provision of the Immigration Act violated the fundamental principles of justice in Section 7 of the Charter. And so very quickly we have the court expressing itself as a firm defender of charter rights in the face of legislative authority. And remember, the previous deference to legislative authority that the courts had shown throughout the pre-charter era was quickly being reversed. Two additional court cases help us understand how the court is willing to apply the Charter and with what scope and authority it will do so. These two cases have to do with the right to strike under the Charter and whether this right exists at all. It's going to help us understand whether the framers' intent, that is to say, the will and intent of those who framed and wrote the Charter, whether that matters more than the interpretation of the justices who are tasked with protecting the Charter and upholding the rights that are entrenched within the Charter. And so we see that originally the court held that there was not a legal right to strike under the Charter. In reference regarding Public Service Employee Relations Act, 1987, the Supreme Court denied that the Charter protected the right to strike, since the Charter did not have any specific things to say about economic rights, since it was clear that the drafters of the Charter were deliberately silent on economic rights. The court believed that this meant that if the framers had wanted to include a right to strike, they would have done so, and that the framers' silence on this issue meant that there was not a right to strike. However, this decision and the precedent of decades of decisions that held that there was not a right to strike was reversed in Saskatchewan Federation of Labor versus Saskatchewan from 2015. And this decision reversed decades of precedent by holding that the right to strike is protected as part of the fundamental freedom of association in Section 2 of the Charter. The framers of the Charter might not have explicitly mentioned the right to strike, but the interpretation of the justices that the right to strike is clearly part of the freedom of association protected by Section 2, this is the argument that won the day in the 2015 court case. And so we can see here that there's always going to be a tension between the intent of the framers, those who authored the Charter, and the interpretation of the justices, whose job it is to interpret the Constitution and to review laws when they may conflict with the rights entrenched in the Constitution. Now let's examine state-society relations. That is to say, how should we apply the Charter when individual rights and group rights or national concerns and values come into conflict with one another? Individual rights and freedoms related to as many issues as limits on police powers, the rights of the accused, women's access to abortion, and marriage equality are all better protected because of the Charter. But in some cases involving individual rights and freedoms, the courts are called to balance these Charter guarantees against interests such as national security, community safety standards, or other democratic and social values. For instance, we've already discussed the limitations on individuals' ability to donate to political campaigns. This is a limitation that does not exist in the United States, but which the Canadian Supreme Court decided that equality is more important than the individual right to donate unlimited amounts of money to political campaigns. And so we can see here that while the court has expanded individual rights in certain areas, in other decisions, it has decided more in favor of national values to decrease individual rights where there's a compelling reason and only a reasonable limitation on the Charter rights. Let's take a closer look at some of these issues. Specifically, I want to focus on two recent court decisions regarding the niqab. The niqab is a veil worn by some Muslim women for religious reasons. And these two court cases illustrate the tensions that exist when we attempt to protect competing rights in a multicultural society like Canada. In the case of R versus NS from 2012, the question at hand was, should a person wearing a niqab be required to show her face when testifying in a criminal trial? This case highlights the tension between the right of free religious expression, which is in the fundamental freedoms portion of the Charter in Section 2, against the right for a fair trial. And the legal rights that exist in Sections 7 through 14 clearly say that people are required to have a fair trial. Is someone giving evidence against you in a trial without anyone being able to see that person's face while they give evidence? Is that going to violate your access to a fair trial? And so the court decision said that the court must balance the reasonable right of someone who is sincerely wearing a niqab to practice that unless it is clear that it would violate the fairness of the trial. And so it created a test for trying to decide between these two competing values, that of the right of a fair trial and the right of a witness to free religious expression in the courtroom. Secondly, in Ishaq versus Canada, a federal court held that the government cannot force a woman in this case Zunera Ishaq, to remove her niqab in order to take the oath of citizenship. The government argued that Zunera Ishaq did not have to take the oath of citizenship if she did not wish to comply with the policy of removing the niqab for the oath, that the rights of permanent residence would still be given to her. And yet Zunera Ishaq won this case, and the government cannot ban this practice. And so we see here again that this is an issue that is especially controversial. First, because the issue of the niqab and whether it is worn is already not an issue that is universal and universally held within the Islamic religion. And then secondly, the confrontation between the historically Anglo-Protestant and Francophone Catholic populations with the symbols of different religions is an issue that we're going to see is still a very prominent one, especially in the case of Quebec and Bill 21. So, in the area of criminal law, the Supreme Court has rebalanced the relationship between the individual and the state, mostly in favor of the individual. Reverse onus provisions, such as the one in the former narcotics law that said it was incumbent upon the individual to prove that he or she was innocent of drug distribution just because they were found guilty or accused of drug possession. This is a reverse onus provision, and instead it says no, the burden of proof is on the state, not on the individual. Also, search and seizure powers have been restricted in many ways, and limits have been placed on the length of time that those accused of criminal offenses have to wait to stand for their trial. But, as we've mentioned in other areas, the Supreme Court has favored societal interests and values over individual rights, such as in the case of R versus Kijkstra, which prohibits hate speech in important ways, and Harper versus Canada, which prohibits unlimited campaign donations. In these areas, the Supreme Court, when applying the Charter, has sided on the side of societal values over individual rights. And so the general tendency here is a mixed bag of, in some cases, the courts standing up for the entrenched rights of the individual in the Charter, and in other cases, valuing societal interests. And so in this way, there isn't a clear trend one way or the other, and instead it's important for us to keep looking at these issues on a case-by-case basis, and the importance of reading judges' decisions, both majority decisions and occasionally important dissenting opinions, to understand the future trajectory of charter cases and rights claims. We're going to finish our examination today with an important topic that very well might come up before the Supreme Court in future years. And this topic is Quebec's Bill 21. Bill 21 is an act of Quebec's legislature that bans the wearing of religious symbols by some public sector employees. These public sector employees who cannot wear religious symbols at their job include police officers, judges, and teachers in public schools. Quebec invoked the Notwithstanding Clause, Section 33, in order to avoid claims that Bill 21 violated fundamental freedoms in Sections 2 and 7 through 15. Remember, the Notwithstanding Clause allows provinces to pass laws that place limitations on Sections 2 and 7 through 15. However, outside of Quebec, critics denounce Bill 21 as clearly discriminatory and unconstitutional. But these critics are partially frustrated by the invocation of the Notwithstanding Clause. Because Quebec's legislature invoked the Notwithstanding Clause, legal challenges are most likely going to have to pursue avenues other than Sections 2 and 7 through 15. And there are a few different ways in which critics of Bill 21 claim that the Act violates other parts of the Charter that the Notwithstanding Clause does not give Quebec an opportunity to limit. This includes, for instance, the argument that the bill disproportionately impacts Muslim women. This violates Section 28 of the Charter's guarantee of gender equality. Furthermore, Critics of the bill argue that it violates Anglophones in Quebec, Anglophones' educational rights under Section 23 of the Charter. And so we can see that beyond the fundamental freedoms, there are also challenges to Bill 21 on the basis of gender equality and educational rights. And so the battle over Bill 21 highlights a number of tensions that we can observe in Canadian politics that are related to today's topic of the protection of rights and freedoms under the Charter. First, we can see the tension between the provincial use of the notwithstanding clause and the Charter's guarantee of fundamental freedoms. We can also see the tension between the overwhelming support for Bill 21 inside of Quebec and the opposition to Bill 21 in the rest of the country, that there is a tension between the French-inspired Enlightenment liberalism that promotes liberal values by banning religious symbols in public, by promoting strict state neutrality, and promoting gender equality. This is contrasted with a broader multicultural liberalism in Canada that tends to promote religious and cultural accommodations in public spaces. And clearly, these two visions of what liberalism ought to be, strict state neutrality and the banning of religious symbols in public, or the multicultural accommodation of religious and cultural differences, these are at the heart, as well as the different emphasis of different provisions of the Charter, whether it's the notwithstanding clause or the fundamental freedoms or gender equality. These issues, these tensions, they are all at the heart of the debate over Bill 21, which illustrates why it is such a controversial topic. As noted earlier, Freedom House reduced Canada's score from a 99 out of 100 to a 98 out of 100 because of Bill 21. So the entire world is taking notice of this act of the Quebecois provincial legislature. And the ultimate fate of Bill 21 is almost certainly going to be decided sometime in the next few years by the Supreme Court. After today's lecture, knowing what you now know about the protection of rights both in the pre-charter era as well as after 1982, the scope and authority of the court's ability to protect those rights, the tensions between individual rights and societal values, how do you think the court will decide? This is an important topic for reflection that will help us consider the importance of protecting charter rights and an important topic in the soon-to-be future of Canadian politics. How do you think the court will decide on this issue? In addition to thinking about that topic, we also have the regular assignment this week of our lecture reflection assignment. Based on the reading material from Chapter 7 of our Brooks textbook, as well as today's lecture reflection, today's lecture material, please write a 7 to 10 sentence response to the following question. Compare the Canadian Charter of Rights and Freedoms to the United Nations Universal Declaration of Human Rights. What are the main similarities between the two, and which other aspects of the UN Declaration should be adopted by Canada? I've given you the links to both documents here, so you can take a closer look and compare the two different ways of trying to protect rights and freedoms. As always, use careful paraphrasing in your own words, but you'll notice that there is an extended deadline on this week's lecture reflection. Normally, these are due on Wednesday nights, but given the fact that we have a midterm to study for this week, I am extending the deadline on this assignment to midnight on Sunday, February 14th. You can submit it just before midnight on Sunday night instead of on Wednesday night. This is going to give you more time this week to focus on preparing for the midterm. And speaking of which, at the end of this week, I will release the midterm prompt on Thursday evening, and then it will be due 24 hours later. And so you have the midterm to study for. I sent you this morning a study guide with all of the topics that are going to be covered on the midterm. Now, the study guide also includes some topics that won't be on the midterm because I can't make it too easy for you. I can't give you just every single topic that's covered and no extra information. I'm going to make you study a few extra topics in order to make sure that you know everything that's going to be on the exam. So carefully look at the study guide, go over it with your teaching assistants in discussion group and in tutorial. And I'll have office hours throughout this week to help answer any last-minute review questions that you might have in advance of the midterm. Until then, good luck studying, be safe, be well, and I'll talk to you soon.